Good morning, good day, Namaskar. This is January 30, 2021, and this end is speaking Suraj, Engineer Suraj Singh, Chartered Engineer Bharat, Professional Engineer, International Professional Engineer, Civil Engineer, in your service, presenting to you certain talk, screen share through Facebook Live. Title being Civil Field Engineering Designs, Methods, Contracts, FIDIC, Construction Organizations, Communications, Coordinations, Project Quantity, Quality. Why should you be behind quality all time, standard materials and concrete, whatever it is. Means miscellaneous types of talk for awareness of general public as well as for professionals. Professionals must be aware about this, but even then it's better to refresh everybody. Is talk to you for national interest, particularly in our country, because we are far behind in quality achievement. In 95 to 98% cases, quality is not achieved, particularly in construction industry, as it should be. It's really unbecoming on our part not to care to achieve quality to that level, at that level it should be, rather than because non-professionals are involved in construction. In many cases, particularly on very small projects, some medium class projects, and even on major projects, who bothers? Even you are a professional but you don't have experience, in that case I cannot say that you are a quality engineer. A quality engineer means first your qualification and your experience must be matching to requirement. You should conform to what is actually required, and then you should have enough experience, enough update on systems, on quality, on advancement of technology. All these are required. But sometimes it is seen that it doesn't happen. Unfortunate it is, I should not say. It's culture that we have adopted so far. Our working culture is not dynamic, it is not dynamically changing. Really, it is not that one. Good morning, Mrs. Chaudhary Raju. You are welcome. I am happy that you are still not sleeping. Good, very good. Fine. Thank you very much. बहुत बहुत धन्यवाद. And now I am going to talk to you about construction working, how construction works. How construction world works, that is very important to know first rather than jumping onto everything. I have talked in past also about various issues related to designs, construction, and various other sub-disciplines that are involved in construction industry. Construction that involves around 70% of budget of this country as well as other countries is very important world, and if we keep quality issue on that, I think we can be called best in world. But that doesn't happen. Quality system has never gone to that level. It was expected or it must. It has not done. It has not gone to that level. It should have been. I don't know reason behind that. I think absence of world culture, absence of, you can say, approach, or you can say target of money making. That's one reason behind that. Because this world is hand of promoters, builders, and those who are in high wealth, those riches, for whom money is everything, not quality of construction. And then quality of construction is not cared for by all. That means it would fall, it would not achieve those standards it is required to do. थोड़ा अपनी भाषा में भी बोल देते हैं. हम भारतवासी आज की दुनिया में अभी भी वहीं खड़े हैं जहां पहले खड़े थे. कंस्ट्रक्शन की क्वालिटी के बारे में, कंस्ट्रक्शन की क्वालिटी जो होनी चाहिए वो अभी तक हमने नहीं हासिल की है. करनी चाहिए थी, लेकिन किसी भी वजह रही हो, हमारे ठेकेदार, हमारे प्रमोटर, बिल्डर और हमारे प्रोफेशनल्स शायद जागरूक इतने नहीं हैं, न थे. होने चाहिए अब, लेकिन अभी भी नहीं हैं. जगह जगह आप देखिए क्वालिटी इतनी ख़राब जाती है, कई बार तो देखना भी मन नहीं करता. सरिया ख़राब, कंक्रीट ख़राब, जगह जगह कैसे भी रिपेयर कर दो, कोई पूछने वाला नहीं, खोद के चल दिए, कोई कंट्रोल नहीं, कोई सेफ्टी नहीं, कुछ नहीं, और है तो दिखाने के लिए बस कुछ कोन रख दिए, टेप लगा दी, दिखा दिया कि सेफ्टी है, क्योंकि सेफ्टी में भी क्वालिटी चाहिए। अगर क्वालिटी नहीं तो कंस्ट्रक्शन नहीं। मैं एक ही बात जानता हूँ, हमारा पैसा 60-70% कहाँ जाता है? हमारा पैसा डेवलपमेंट में जाता है, देश की डेवलपमेंट। उसको आप सिविल इंजीनियरिंग भी कह सकते हैं, जिससे और दूसरी इंजीनियरिंग मिली होती हैं, लेकिन ऐसा नहीं है। वेल, इट्स नॉट फॉर मी टू डिसाइड, आई एम जस्ट गिविंग माई ऑब्जर्वेशन। योर ऑब्जर्वेशन कैन बी डिफरेंट। एवरीबडी हैज़ अ राइट टू स्पीक, एंड बीइंग ए प्रोफेशनल, senior professional, it's my duty to generate awareness among people of my country as well as all others. What's happening, what should not happen. We have nothing to hide. In engineering, you cannot hide anything. That's also a fact. You may be working in whatever country. Engineering is such a world where nothing can be hidden. You can't hide. It happens. Buildings collapse, roofs collapse. You can say roads sink. Sewer lines are broken. It happens. Building gets fire, ablazed, short circuit or whatever, means there is every chance that quality collapse exists. It may be in electrical engineering, it can be in HVAC, fire damper didn't work, it can be volume control damper didn't work, it can be also said the system didn't work or machines did not work. Whatever you can say, whatever. There is some relation to quality. It may be, you can say, fall in civil construction quality, or it may be drop in electrical consideration, or it may be drop in HVAC or some other. So every sector, every discipline is responsible to some extent about loss of quality. We did not achieve, we never tried to achieve, we kept ourselves down, and that quality is very important to be controlled, to be organized. When I say quality, it's a gross word, it's a level 1 word I can say. Quality means whole quality, whole system where involvement exists. Your system should be quality oriented, it cannot be off orientation of quality. If your system is not quality oriented, it's very much true that you can't do anything. Fortunately, it's different world now. You have to decide for yourself what quality you achieve, what you have planned to achieve, what's your intention, and what organizations of standardizations speak or demand. ISO 9000 organization or Sigma or whatever else you follow, what actually do they demand? That is, you have to decide, you have to select, and then based on that selection, you have to define your quality policy. It's very important point. If you don't do that, you can't. And this is your liberty. This is your liberty, you can say. This is your liberty that you have to decide for yourself and do it for yourself. That's also important. Do it for yourself. You can't simply run away from that. You have to prove, you have to establish that you have followed that system. So it is in your hands. There is no police on that. There is no military on that. You are executor of that system. You are decider of that system. Means you are a designer of that system. You are a planner of the system. You are conditioning yourself for the system. If you are not conditioning well, means you lose something. It's very much common that ISO 9001 or others are not new now, but it's also observed since these systems came into being. Systems are very nice, they are running very fine, they are advancing every year. Now ISO 9001 and 2015 is there, but if you compare quality system when there were no systems at all, where there were no quality organizations at all, when I was in 70s or 80s, you can say 90s, I think that time quality working was much better than it's working now, because people had some culture, internal culture, developed culture, means they had intention that we have to work. And package work people were doing, used to do, for example, I used to do all acts of, I involved myself in all sub-disciplines of my profession, that's civil engineering, construction engineering. But now what's happening? There have been various disciplines out of one engineering. For example, in every engineering there are so many disciplines like quality, like safety, like construction, like design, like quantity surveying, and whatever you can say. tendering, etc., etc. There are sub-disciplines, and everybody says that I am expert of this and I am expert of that. In fact, this is a confusion, there is a mix-up, because yes, you may be expert in one of these disciplines, but you are not expert in profession, because profession involves every discipline. Without absence, or you can say without presence of one sub-discipline, project cannot move. Project demands input from all these disciplines and sub-disciplines. When I say disciplines, mean disciplines of multidisciplinary engineering like civil, electrical, mechanical, or you can say IT and all others. All those disciplines are required to be incorporated into every project. That's modern definition of project, because project has certain power. It requires every discipline to give it to something, and that's where we say some disciplines and sub-disciplines are required, and every discipline has sub-disciplines. For example, civil engineering has all disciplines in design discipline, means construction discipline, and before that tendering discipline, and you can say quality is a must and safety is a must, and you can say all disciplines are there. Similarly, in HVAC, of course, HVAC design doesn't mean that much, because it comes from factory oriented design comes, and means you can say customized design machines are available, and same thing applies to electrical engineering and also IT, which are already defined, but only discipline, that is civil engineering discipline, which is very much powerful, because everything is to be decided on site, on project, and according to requirement, according to budget, and it is not changed immediately. So it has to meet requirements of mechanical engineer, electrical engineer, and all other engineer as far as construction building is concerned. As for construction building is concerned, which is very important part, building or structure has to support each these disciplines. So we have say civil engineering is a kind of multi-support engineering with multi-discipline advancement or lead, and civil engineering is first in engineering which comes in front. You can say when you start something, it's civil engineering start. You have to clear site, clear garbage, clear everything, and then you have to conduct surveys. And so you can say from initial beginning, from scratch of land, you have to move into construction world, and that's very important point for we should be proud of that. Every engineer should be, although you are not well diplomat there, you're not having very good dressing and all that, and you may be looking very awkward by your dress system or our face, because dust is on our face, and your clothes may not be well stitched or well ironed. Well, it doesn't matter as far as mind application is concerned, because you are applying mind in sun and every in all weather condition, and that's your beauty of engineer, civil engineer is concerned. And that's point I'm very pridefully saying that you are going to work for society all over the world in a beautiful fashion, standing in sun, conducting surveys, and then you have no water sometime to drink, and you are in field or in desert or in forest. It depends wherever you are. You are original worker, you are a worker, you are not a leader. In fact, you are above leader, because without your work, leaders cannot do, professionals cannot do. So that's what I'm saying. I'm defining civil engineering from virtual point of view, practical point of view. It's very important. We have to understand what is engineering. Obviously, I don't want to define it every day, because you know what is engineering, but we have to see by definition of engineering what do we understand, and that's very important. And from that point of view, I was explained to last time also, though I was not very well in that time, about conditions of contract, how contract works, and contract is very important, because without contract no work can move. Though we can move ourselves, but without construction engagement, it's not possible to move any project, because of various specialties, various items are involved, various resources are involved. We have to arrange human resources, we have to arrange material resources, we have to arrange machine resources. And also technology is available, methods are available, or you have to generate method statements and procedure statements and quality system, and you can say we have to comply with manufacturers' instruction, because there are so many products, chemicals, admixtures that are used from, there's a proprietary designs of industrialists, or you can say manufacturer, and we have to comply with them. All these joint applications move on site, and these are called construction activities. And before that, we have to do design activities, which are done separately, individually, but those are related to construction directly, because if design is excellent one, a lot of input has been given to design. But if construction man doesn't do this, if construction person who doesn't Doesn't do two requirement, it doesn't be requirement. This means design cannot be given shape in construction. So there is defective construction, deficient construction if compared to design. So design did not work, doesn't work there. This is another lost article because the construction is over, but it's not quality construction, doesn't matter requirements, and you can say we have got losses because design and construction should move together, and then comes safety and quality on that, which are on additional, now you can say value, which additional value to design. Your construction means quality, construction means quantity, construction means safety, construction means average system, construction means dispute free environment, and that's what we say construction. And contract is very important because one person cannot do everything. If you are involved in design, it's difficult to be part of construction simultaneously. Similarly, previously construction used to have, everybody in construction used to take care of safety, take care of quality, take care of, you can say, tendering, take care of everything, but now it's a different world. There are so many departments in construction. This has been for last 20 years. You will find completely different system. Every department is specialized from design to end delivery, or when you declare completion of project, because project is a temporary one, it's not permanent. No project can be permanent because project has to be delivered to owner, and then it has to come to operational status, from where means either it is giving deliveries, it is giving production, or when project is over, it is declared means no more project, it's now operational unit. It could be oil operational unit, it could be a commercial building, it could be industrial building, it could be your residential building, it could be road commission, it could be flyover commissioning or railway commissioning or whatever you can say, airport commissioning. When you declare it's no operation, means that a project is closed. This means there are two dates of every project, commencement date and end date, and this date duration, the gap between two dates is called gap, or you can say the defined duration of project. And that is very important point of view, and where we have to understand that from conditions of contract for construction, which is really marvelous. We have to understand, though it's not mandatory, but it's really marvelous that we have to understand in sequence logically what are contract conditions. I have gone through this document through you, and we have learned many aspects of this last time and before last time also. What is construction contract? What FIDIC says? FIDIC means an organization to standardize contract documents. Contract, not documents, but contract forms, I can say. We had gone through this chart, this typical sequence of principal events during contracts for construction, and then it was typical sequence of payments, events, and we says in class 14, and then we can say one that we have to understand by explanation, and then typical sequence of events in agreement of determination or under subclass 37, scenario 1, scenario 2, scenario 3, like that we had gone through, and we were then talking of our what are contents of this, which are very sequential. General provisions, then employer definition, then engineer definition, then contractor definition, subcontractors and staff and labor, and you can say plant material and workmanship, commencement delay and suspension, test on completions, employers taking over, defects after taking over, and measurement and valuation, variations, adjustment, contract price and payment, and then termination by employer. And you can say care of works and indemnities, then exceptional events, insurance, employers, contract claims, and dispute resolutions. Better for everybody, it's easy to understand the sequence, because the sequence is very simple. It's a general provisions, it is just giving general outlook of what a contract is, means what to deal with. For example, it's a definitions regarding various parties, definition, then their interpretation, then notices and work communications, laws and language, priority of documents, contract agreement, assignments, care and supply of documents, delayed drawings for instructions, employers use of contracts, documents, contractors use of contractors' documents and contractors' use of employers' document, confidentiality, compliance with laws, joint and several liability, limitation of liability, and contract termination. These are all very general from, you can say, start to end. And then employer, we have to define what's employer. What employer is, means what honor is, means a complete definition of that is there. An engineer, what is duty of engineer, authority and representative and delegation of by engineer, instruction etc. is complete, and the contract is complete. Contracts, general obligation, performance, security, contracts, representative, contracts, documents, training, cooperation, setting out health and safety obligations, quality management and compliance verification systems, use of site data, sufficiency of accepted contract amount, unforeseeable physical conditions, right of way and facility avoidance of interference, access routes, transfer of goods, contractors, equipment, protection of environment, temporary utilities, progress reports, security of site, contracts operations on site, archaeological and geological findings, and subcontractors, nominate subcontractors, then staff and workers, engagement staff and workers, and rates of wages and conditions, labor recruitment of persons, labor laws, working hours, and facilities for staff and labor, health and safety of persons. Aid safety of persons, contracts, superintendents, contracts, personal contracts, records, disorderly of conduct, key persons, plant manager, and workmanship, manner of execution, samples, inspections, testing by contractor, defects and rejection, remedial works, ownership of plant and material and royalties, commencement, delays and suspension, commencement of works, time for completion program, advance warning, extension of time for completion, delays caused by authorities, rate of progress, delay damages, employer suspension, consequences, employer suspension, payment for plant and material after employer suspensions, prolonged sections. Defects, notification period, failure to remedy defects, remedying of defective work on site, further tests after remedying defects, rights of access after taking over, contractors to search, performance certificate on fulfill obligations, clearance of site, measurement and valuation, work to be measured, method of measurement, valuation of works, omissions and variations and adjustments, right to vary, value engineering, variation, procedure, provisional sums, day work adjustments for changes in loss, adjustments for changes in cost, contract price and payment, contract price, advance payment, application for interim payment, schedule of payment, plants and material intended for works, issue of IPC, payment, delayed payment, release of retention money, statement at completion, final statement, discharge out, issue of FPC, final payment certificate, cessation of employer's liability, currencies of payment, and then termination by employer, notice to correct contractor's default, payment after termination for contractor's default, termination for employer's convenience, valuation after termination of employer's convenience, payment after termination for employer's convenience, suspension and termination by contractor, suspension by contractor, termination by contractor, contract's obligation after termination, payment after termination of contractor, care of works and indemnities, responsibilities for care of works, liabilities for care of works, intellectual industrial property rights, indemnities by contractor, indemnities by employer, shared indemnities, exceptional events. Exceptional events and nothing is same thing as force majeure is to be in 2008 one. Exceptional events, notice of an exceptional event due to many duty to minimize delays, consequences of exceptional event, optional termination, release from performance under law, insurance, general requirements, insurance to be provided by contractor, employers and contractors, claims for payment, annuity, extension of time, and disputes and arbitration. That's the 21 Constitution of DAAB. Failure to appoint DAAB members, avoidance of disputes containing DAAB decision, amicable settlement, arbitration, failure to comply with DAAB decision, no DAAB in place, and general conditions of disputes avoidance, education agreement, and then you can say here we have to move with all this we talked last time. These conditions: accepted contract amount, advance payment certificate, advance payment guarantee, base date, bill of quantities, claim, commencement date, compliance. All these conditions are there which are defined. All these terms are defined. We have to understand them. If we have to one go again and again, we have to understand them. In one go, you may not understand everything. No problem. We have to understand them all the time, and we have to see what to do, what not to do. That's very important point in contracts. Interpretation we have gone through in this, and we have understood that notice documents, for example, part A, then particular condition part B, and then we can say general condition. if a party finds an ambiguity, if a party finds that part that party shall promptly give a notice to engineer describing ambiguity or discrepancy. After receiving such notice, or if engineer finds an ambiguity or discrepancy in documents, engineer shall issue necessary clarification or instruction. सो ये डॉक्यूमेंट्स हैं, जो दस्तावेज हम बात कर रहे हैं आपसे, हमने जो अभी तक बात की, क्या क्या टर्म्स कंडीशंस हैं, क्या मतलब होता है इनका, ये सब आपके सामने है। इनके इंटरप्रिटेशन भी हमने आपको बताया, इसके मतलब क्या होते हैं वो आपने पढ़ ही लिए होंगे। ही के साथ शी भी लगता है, शी के हिस के साथ हर भी लगता है, ये लॉ में होता है, कोई नई चीज़ नहीं है। और एग्री और एग्रीमेंट और एग्रीड सब डिफाइन करना पड़ता है, सब रिटर्न में होना चाहिए। और मे मीन्स आपकी अथॉरिटी में है, आप चाहें उसको यूज़ करें चाहे ना करें। शेल का मतलब यूज़ करना ही पड़ेगा। कॉन्सेंट का मतलब क्लियर है। कॉन्सेंट मीन्स एम्प्लॉयर, कॉन्ट्रैक्टर और इंजीनियर हैज़ केस में भी एग्री टू गिव परमिशन फॉर रिक्वेस्टेड मैटर। कंसेंट भी हो सकती है, ये अप्रूवल भी हो सकती है, इंक्लूडिंग वगैरह सब एक ही मीनिंग है। और ये आप चाहते हैं कोई बड़ी बात नहीं है इसमें। और जो भी नोटिस आपको देना है, राइटिंग में देना है, अगर ये नोटिस कॉन्ट्रेक्चुअल नोटिस है तो उसमें आपको रेफरेंस भी देना होगा कौन से क्लॉज के अंडर ये है। और कम्युनिकेशन सारी राइटिंग में होनी चाहिए। कम्युनिकेशन की बहुत सारी टर्म्स हैं। वे वी डिफाइन वेयर एवर दीज कंडीशंस प्रोवाइड फॉर गिविंग ऑफ ए नोटिस, इंक्लूडिंग ए नोटिस ऑफ डिससेटिस्फैक्शन और issuing, providing, sending, submitting, transmitting और another type of communication। देखिए क्या क्या कहा है इसमें। देखिए, नोटिस ऑफ डिससेटिस्फैक्शन, नोटिस तो आएगा या इशू कीजिए, बताइए, दीजिए बना के, प्रोवाइड कीजिए, भेजिए, उसको सबमिट कीजिए, ट्रांसमिट कीजिए, और कोई और कम्युनिकेशन को आप ट्रांसमिट कीजिए। और इंक्लूडिंग जैसे एक्सेप्टेंस है, एक्नॉलेजमेंट स्वीकारता है, एडवाइजिंग, एग्रीमेंट, अप्रूवल, सर्टिफिकेट, क्लेम्स, कॉन्सेंट, डिसीजन, डिटर्मिनेशन, discharge, instruction, no objection, records of meetings, permission, proposal, record, reply, report, request, review, statement, submission, or any or whatever other similar type of communication, notice or other communication shall be in writing and shall be। अब देखिए इसमें सारी स्टेज दी गई हैं जो भी कॉन्ट्रैक्ट की स्टेज होती है, बिफोर कॉन्ट्रैक्ट, ड्यूरिंग कॉन्ट्रैक्ट, क्या क्या कम्युनिकेशन स्टेज आ सकती है। वट एवर स्टेज यू गेट or you find throughout contract currency, all are defined here and which must be understood. And again I repeat this, it's very important one. Wherever these conditions provide for giving of a notice, including a notice of dissatisfaction or issuing, providing, sending, submitting or transmitting of another type of communication, and including acceptance, acknowledgement, advising, agreement, approval, certificate, claim, consent, decision, determination, discharge, instruction, no objection, records of meeting, permission, proposal, record, reply, report, request, review, statement, submission, or whatever other similar type of communication, notice or other communication, all shall be in writing and shall be a paper oriented signed by contractor's representative, a paper original signed by contractor's representative, engineer or authorized representative of employer as would be case, an electronic original generated form, an electronic original generated from any of systems of electronic transmission stated in contract data, if not stated systems acceptable to engineer, where electronic original is transmitted by electronic address uniquely assigned to each of such authorized representative। आप इसको समझ गए होंगे। ये कॉन्ट्रैक्टर के रिप्रेजेंटेटिव द्वारा साइन किया पेपर या इंजीनियर द्वारा साइन किया पेपर ओरिजिनल, या इंजीनियर या एम्प्लॉयर के ऑथराइज रिप्रेजेंटेटिव साइन किया पेपर होना चाहिए। और इलेक्ट्रॉनिक ओरिजिनल हो सकता है जिसको सिस्टम ने जनरेट किया हो, इलेक्ट्रॉनिक ट्रांसमिशन की गई हो, वो कॉन्ट्रैक्ट डाटा में कहा गया हो, इंजीनियर को मान्य हो, इलेक्ट्रॉनिक ओरिजिनल ट्रांसमिट किया जाए उसी एड्रेस पे जो एड्रेस दिया गया है। इफ़ इट इज़ ए नोटिस, अगर ये नोटिस है, इट शैल बी आइडेंटिफाइड एज ए नोटिस, टाइटल नोटिस होगा। इफ इट इज़ अनदर फॉर्म ऑफ कम्युनिकेशन, it shall be identified as such and include reference to provisions of contract under which it is issued where appropriate. Delivered by hand against receipt or sent by mail or courier against receipt or transmitted using either of systems of electronic transmission under subparagraph above. नोटिस का टाइटल होना चाहिए नोटिस, और वो कौन से क्लॉज में दिया गया है वो उसमें ज़रूरी है, क्योंकि नोटिस एक लीगल डॉक्यूमेंट होता है जो कोर्ट एक्सेप्ट करता है। प्रोसीजर में नोटिस ज़रूरी होता है। कोई दूसरे लेटर हो, दूसरे मीमो हो, अलग बात है। और हाथ से देना, रिसिप्ट से देना, कोरियर से देना, मेल से देना, जो भी सिस्टम है उसके हिसाब से देना मान्य होता है। और डिलीवर किया जाए, भेजा जाए, डिलीवर, सेंट और ट्रांसमिटेड टू एड्रेस फॉर रेसिपिएंट कम्युनिकेशंस स्टेटेड इन कॉन्ट्रैक्ट डाटा। हाउएवर, if recipient gives a notice of another address, all notices and other communications shall be delivered accordingly after sender receives such notice. Or other communication is to be delivered transmitted notice or other communication is deemed to have been received on day sender. All notices and all other types certificate is issued by a party or engineer. Paper and or electronic original shall be sent to intended recipient, and the copy shall be sent to engineer or other party as case may be. All other communications shall be copied to parties and or engineer as stated under these conditions or elsewhere in contract. उसके बाद लॉ एंड लैंग्वेज के बारे में हमने आपको बताया पहले ही। लॉ की लैंग्वेज अगर डिफाइन, लॉ में लैंग्वेज डिफाइन नहीं है, कॉन्ट्रैक्ट में लॉ कौन सा लगेगा, कौन से देश का, या लैंग्वेज डिफाइन नहीं, इसके बारे में देखिए क्या कहता है। फिर मैं आई रिपीट, कॉन्ट्रैक्ट शैल बी गवर्न बाय लॉ of country or other jurisdiction stated in contract data, and if it's not stated, law of country excluding whatever conflict of law rules. Ruling language of contract shall be that stated within contract data, and if not stated, language of these conditions. If there are versions of some part of contract which are written in more than one language, version which is in right ruling language shall prevail. Language for communications shall be that stated in contract data. If no language is stated there, language for communications shall be ruling language of contract. प्रायोरिटी ऑफ डॉक्यूमेंट्स, जैसे मैंने आपको पहले बताया, बहुत इंपॉर्टेंट पॉइंट है, हमें समझ आना चाहिए। पहला कॉन्ट्रैक्ट एग्रीमेंट होता है, मैं इंग्लिश में बाद में बता देता हूँ आपको समझाने के लिए। सबसे इम्पोर्टेंट डॉक्यूमेंट होता है कॉन्ट्रैक्ट एग्रीमेंट, जिसमें प्राइस वगैरह दिया होता है और डिटेल्स थोड़ी थोड़ी दी होती हैं, जिसमें आप कह सकते हैं अटैचमेंट होती है, उसमें क्या क्या लिस्ट में क्या दिया है वो सब दिया होता है। प्राइस कितना है, लिक्विडेटेड डैमेज कितनी है, प्रोजेक्ट ड्यूरेशन कितनी है, और छोटी मोटी इंपॉर्टेंट बातें, परफॉर्मेंस बॉन्ड कितने का बनेगा, या जो भी उसमें दिया है, कुछ भी इम्पोर्टेंट कॉन्ट्रैक्ट एग्रीमेंट में दिया होता है। और उससे पहले आपका बिड हम एक्सेप्ट कर रहे हैं, उसको बोलते हैं लेटर ऑफ एक्सेप्टेंस। पहले एग्रीमेंट आ गया, फिर लेटर ऑफ एक्सेप्टेंस आ गया, सीक्वेंस देखिए आप। और उससे पहले आपने टेंडर सबमिट किया, तो वो टेंडर, लेटर ऑफ टेंडर का आपका डिमांड और टेंडर की। उसके बाद में कंडीशंस आती हैं, पर्टिकुलर कंडीशंस, पार्टी कॉन्ट्रैक्ट डाटा क्या है, और उसके नीचे स्पेशल प्रोविजंस क्या है, बी। देन जनरल कंडीशन जो हम बता रहे हैं आपको, उसके पहले स्पेसिफिकेशंस एंड ड्राइंग्स, स्केड्यूल्स एंड जॉइंट वेंचर डिटेलिंग। तो देखिए आप, अगर आप नीचे से चलेंगे, जॉइंट वेंचर डिटेलिंग को छोड़ भी दें, स्केड्यूल्स क्या है, उसके बाद ड्राइंग क्या, ड्राइंग देखिए बहुत नीचे है यहाँ पे, जबकि लोग समझते हैं ड्राइंग और स्पेसिफिकेशन सबसे पहले होती है। ऐसा नहीं है, लेकिन टेक्निकल पार्ट आप देखें तो ऐसा ही है, क्योंकि कॉन्ट्रैक्ट एग्रीमेंट, लेटर ऑफ एक्सेप्टेंस, टेंडर लेटर और पर्टिकुलर कंडीशंस एंड जनरल कंडीशंस, ये एक्चुअली इंजीनियरिंग टेक्निकल में नहीं है, ये लॉ टेक्निकल में है। ज़्यादातर इसमें लीगल डॉक्यूमेंट्स हैं। एक किसी कॉन्ट्रैक्ट एग्रीमेंट आप देखें तो लीगल है, लेटर ऑफ एक्सेप्टेंस देखें तो लीगल, इसमें इंजीनियरिंग की कोई चीज़ नहीं है। लेटर ऑफ टेंडर देखें, उसमें भी इंजीनियरिंग की कोई चीज़ नहीं है। पर्टिकुलर कंडीशंस ए एंड बी और जनरल कंडीशंस, ये सारे के सारे डॉक्यूमेंट्री लीगल एविडेंसेस हैं जो कॉन्ट्रैक्ट का हिस्सा है, एक काइंड ऑफ कॉन्ट्रैक्चुअल लीगल डॉक्यूमेंट्स। और उसके बाद स्पेसिफिकेशंस, ड्राइंग्स और स्केड्यूल्स, ये तीनों जो हैं टेक्निकल इंजीनियरिंग है। स्पेसिफिकेशन मोस्ट इम्पोर्टेंट, ड्राइंग्स वेरी वेरी इंपॉर्टेंट, एंड स्केड्यूल्स, एंड देन अंडरटेकिंग दूसरी जॉइंट वेंचर की, और other documents forming part of contract. You have understood now how many documents are there. More than 50% of documents relate to law of contracts. Then fewer like specifications, drawings and schedules, but these are very voluminous documents. Specifications are very voluminous, you can say, in hundreds of pages, many hundreds of pages. Drawings are also in many hundreds in number depending on size of project. And schedules means various schedule, not only time schedule, it could be material schedule, it could be whatever else schedule which it is required to maintain. It can be items schedule, it can be BOQ etc., which is not given here but can be. And whatever documents are there, top, or can say in top at top, recognition of contract and the legal value of contract, it comes from contract agreement, followed by letter of acceptance, followed by tender letter, followed by particular and general conditions, and technically specification stand number 1, drawing stand number 2, and schedules, whatever schedules are there. This is for general information to your point. If a party finds an ambiguity or discrepancy in documents, अगर पार्टी को जो हिस्सा है कॉन्ट्रैक्ट का, उनको इसमें लगता है कि संदिग्धता है, साफ नहीं है, डिस्क्रिपेंसी है इन डॉक्यूमेंट्स में, दैट पार्टी शैल प्रॉम्प्टली गिव ए नोटिस टू इंजीनियर डिस्क्राइबिंग एम्बिग्विटी और डिस्क्रिपेंसी। वो पार्टी इंजीनियर को नोटिस देगी और कहेगी कि देखिए इसमें ये गलत है, या इसमें ये प्रॉब्लम है, एम्बिग्विटी है, डिस्क्रिपेंसी है। आफ्टर रिसीविंग सच नोटिस, और इफ इंजीनियर फाइंड्स एन एम्बिग्विटी और डिस्क्रिपेंसी इन डॉक्यूमेंट्स, इंजीनियर शैल इशू नेसेसरी क्लैरिफिकेशन और इंस्ट्रक्शन। वो कॉन्ट्रैक्चुअल इंजीनियर आपकी इंफॉर्मेशन को देखेगा, जो आपने दिया इंजीनियर को नोटिस एज ए कॉन्ट्रैक्टर, वो देखेगा इसमें क्या सही है क्या गलत है, और उसके बाद जो भी एम्बिग्विटी होगी, डिस्क्रिपेंसी होगी, उसके ऊपर नेसेसरी क्लैरिफिकेशन या इंस्ट्रक्शन आएंगी। सो यू विल गेट ऑल इंस्ट्रक्शन फ्रॉम इंजीनियर, ऑल क्लैरिफिकेशंस इफ यू नोटिस सम डिस्क्रिपेंसी एग्जिस्ट, सम एम्बिग्विटी एग्जिस्ट। कॉन्ट्रैक्ट एग्रीमेंट, contract agreement एग्रीमेंट क्या है? एग्रीमेंट इज ए डॉक्यूमेंट, legal document that has been entered into and signed and executed by both parties on contract, party 1 that is employer, party 2 that is contractor. That is agreement. That is a kind of direct assignment by employer to contractor. And contractor got no further right to sublet that work to someone else, either in part or in full, without taking permission from employer. Neither party shall assign whole or whatever part of contract or whatever benefit of or interest or in or under contract. However, either party may assign whole or whatever part of contract with prior agreement of other party at sole discretion of such other party. Or and may as security in favor of a bank or financial institution assign parties rights to whatever money is due or to become due under contract without prior agreement of other party. ये आपके सामने है. Neither party shall assign whole or part of contract or benefit of interest in or under contract. However, either party may assign whole or part of contract with prior agreement of other party at sole discretion of such other party, and may as security in favor of a bank or financial institution assign parties rights to whatever money is due or to become due under contract without prior agreement of other party. In custody and care of employer, copies of contract and of each subsequent drawing shall be supplied to contractor, who may make or request further copies at cost of contractor. Each of contractor's documents shall be in custody and care of contractor unless and until submitted to engineer. Contractor shall supply to engineer one paper each of contractor's documents shall be in custody and care of contractor unless and until submitted to engineer. Contractor shall supply to engineer one paper original, one electronic copy in form as stated in specification, or if not stated, a form acceptable to engineer, and additional paper copies of stated in contract data of each contract data of each of contractor's document. This is contract, we are talking of, is very important for everybody. We have to understand that contract is a lawful document, is a document which is having legal value and cannot be just taken for granted by people. It's very much legal and it should be taken care of accordingly. Otherwise, you will face problems in future everywhere. If you don't care about this, certainly you will find problems. And these problems are immense. If these documents are not only documents, these are, you can say, life of project. These documents are legal and particularly where people are not serious. These documents are serious. They make you serious if you are not serious. It's very important for everyone, and particularly those people who are in engineering, who are in civil construction. They must understand value of these documents. If you don't understand values of these documents, means you are not caring for engineering, you are not caring for that, which is very important point. It's unfortunate that our engineers, I cannot say everyone, I can say some engineers do not care for this. Some engineers do not care for this, some care for this. And that's where problem lies in. We have to be very much authentic about this, very much legal oriented about this. And if you are not legally oriented, we can say that we do not conform to our job, we do not care for our job. Contractor shall keep all times on site a copy of contract number. Say number one is contract, as we understood. Contract is number one, and there can be no denial to this, because this is contract which governs everything. Then you can say records. Under contractor's records, you can say subclause, whatever it is. Publications, if whatever name in specifications, whatever codes you can say, or whatever methods, or you can say agreements, or whatsoever is there. We cannot define everything in this. Then contracts documents, drawings and variations, notices, and other communications given under contract. Employer's personnel shall have right of access to all these documents during all normal working hours or as otherwise agreed with contractor. If a party or engineer becomes aware of an error or defect, whether of a technical nature or otherwise, in a document which was prepared for use in execution of works, party or engineer shall promptly give a notice of such error or defect to other party or parties. Delayed drawings or instructions. Delayed drawings or instruction title clearly tells what does it mean. Contractor shall give a notice to engineer whenever and details of nature and amount and or incurs cost as a result of a failure of engineer to issue notified drawing or instruction within a time which is reasonable and is specified in notice with supporting details. Contractor shall be entitled, subject to subclause 22, EOT and other payment of such cost plus profit. However, if and to extent that engineer's failure was caused by whatever error or delay by contractor, including whatever error in or delay in submission of any of contractor's documents, contractor shall not be entitled to such EOT एंड और कॉस्ट प्लस प्रॉफिट। देरी जो भी हो काम पे, अगर वो इंजीनियर की वजह से हुई है तो इंजीनियर को भुगतना है, एम्प्लॉयर को भुगतना है। कोई ड्राइंग इशू करनी है, नहीं हुई, इंस्ट्रक्शन इशू होनी है, नहीं हुई, टाइम पे जो भी रीजनेबल टाइम है होनी चाहिए, कोई भी इंजीनियर ऐसा डिले नहीं करेगा। लेकिन कभी कभी गलती से हो जाए या वो गलती कॉन्ट्रैक्ट की वजह से हो, दोनों को कंसिडर किया जाएगा। अगर टाइम पे इंजीनियर ने इशू नहीं की कोई इंस्ट्रक्शन या ड्राइंग जो ज़रूरी है तो उसको उसका भुगतान करना पड़ेगा। अब मैं कॉन्ट्रैक्ट के डॉक्यूमेंट जो सबमिट हुए हैं उसका यूज़ in contractor's documents and other design documents if whatever made by or on behalf of contractor। कॉन्ट्रैक्ट के जो भी दस्तावेज काम हेतु सबमिट किए जाएंगे, इंटेलेक्चुअल प्रॉपर्टी राइट्स वो कॉन्ट्रैक्टर का ही रहेगा। एंड डिज़ाइन डॉक्यूमेंट जो भी होंगे, कॉन्ट्रैक्ट शैल बी डीम्ड बाय साइनिंग कॉन्ट्रैक्ट एग्रीमेंट to give employer a non-terminable, transferable, non-exclusive, royalty-free license to copy, use and communicate contractors' documents and such other design documents if whatever including making whatever including making any and using modification of them, license shall apply throughout actual। कॉन्ट्रैक्टर जो डॉक्यूमेंट दे रहा है, सबमिट कर रहा है, करेगा एम्प्लॉयर को, इंजीनियर को, वो साफ साफ एक एग्रीमेंट के अंडर होंगे कि कॉपीराइट आपका सही, इंटेलेक्चुअल प्रॉपर्टी राइट कॉन्ट्रैक्ट का सही, लेकिन एम्प्लॉयर को अधिकार है कि वो इन डॉक्यूमेंट्स को ट्रांसफ़र कर सके बिना किसी रॉयल्टी देने के। रॉयल्टी कॉन्ट्रैक्टर को नहीं दी जाएगी और जो भी डॉक्यूमेंट कॉन्ट्रैक्ट संबंधित आए हैं ये ट्रांसफ़र किए जा सकते हैं कॉपिंग द्वारा। ये लाइसेंस दिया जाएगा, ऑटोमेटिकली अंडरस्टूड है, इसकी कोई रॉयल्टी नहीं होगी। इनका यूज़ भी होगा, इनसे कम्युनिकेशन भी होगा, इन डॉक्यूमेंट्स का, वो डिज़ाइन के हों या किसी भी सब डिसिप्लिन्स के हों, इनको यूज़ करना, इनकी कॉपी करना, इनकी मॉडिफिकेशन करना, ये ऑटोमेटिक लाइसेंस समझा जाएगा। टर्मिनेट नहीं होगा ये लाइसेंस और of relevant parts of works। Demolishing works in case of contractors documents and such other design documents if whatever which are in form of electronic or digital files, computer programs and other software permit their use on whatever computer on site and or at locations of employer and engineer and or at other places as envisaged by contract. In event of termination by contract under whatever clause 15(2), entitle employer to copy, use and communicate contractor's documents and other design documents made by or for contractor if certain or under other clause of termination for employer's convenience, entitle employer to copy, use and communicate contractor's documents for which contractor has received payment for purpose of completing works and or arranging for whatever other entities to do so. Contractor's documents and other these documents if whatever made or made by or on behalf of contractor shall not, without contractor's prior consent, be used, copied, or communicated to a third party by or on behalf of employer for purposes other than those permitted under relevant clause. Contractor's use of employer's document. हमने अभी कॉन्ट्रैक्टर्स के डॉक्यूमेंट की बात की कि एम्प्लॉयर इंजीनियर यूज़ करेंगे. अब उल्टा देखिए, इंजीनियर्स के डॉक्यूमेंट या एम्प्लॉयर के डॉक्यूमेंट कॉन्ट्रैक्टर यूज़ करेगा. इसके बारे में क्या है वो भी समझना है. क्योंकि एम्प्लॉयर भी अगर डॉक्यूमेंट देता है तो कॉन्ट्रैक्टर भी दे सकता है. डिज़ाइन इश्यूज़ हैं, दूसरे इश्यूज़ हैं, शॉप ड्राइंग्स हैं, कुछ भी है. As between parties, employer shall retain copyright and other intellectual property rights of specification and drawings and other documents made by or on behalf of employer. Contractor may, at contractor's cost, copy, use and communicate these documents for purposes of contract. These documents, in whole or in part, shall not, without employer's prior consent, be copied, used, or communicated to a third party by contractor, except as necessary for purposes of contract. साफ साफ है. कॉन्फिडेंशियलिटी. अभी क्या बताना था इसमें? भाई आपके डॉक्यूमेंट्स हैं, आपने दिए हैं प्रोजेक्ट के लिए, हमें अधिकार भी है कि हम तो यूज़ करें, लेकिन ओपन यूज़ नहीं होगा, रिलेटिव यूज़ होगा. जो भी आगे हमको सप्लायर हैं, वेंडर हैं, दूसरे हैं, उनको आप उनके उनके मुतालिक जो भी डॉक्यूमेंट हमने देने हैं, उनके आइटम के हिसाब से, उनके स्कोप ऑफ वर्क के कॉन्ट्रैक्ट रखता है, उससे ज़्यादा नहीं. किसी को भी नहीं दे देगा, जहाँ जरूरत है वहाँ देगा, जो वर्क के लिए के साथ ही आपको मिलती है कंडीशंस के हिसाब से. कॉन्फिडेंशियलिटी. कॉन्फिडेंस, आप जानते हैं कॉन्फिडेंस क्या होता है. कॉन्फिडेंशियलिटी क्या होती है आपको पता है, और इसमें कोई नई चीज़ नहीं मैं आपको बता रहा, ये आप जानते हैं. व्हाट इज़ कॉन्फिडेंशियलिटी? कॉन्फिडेंशियलिटी क्या है? और contractor shall disclose all such confidential and other information as engineer may reasonably require in order to verify contractor's compliance with contract. Contractor shall disclose all such confidential and other information as engineer may reasonably require in order to verify contractor's compliance with contract. साफ साफ है, कहीं कोई सीक्रेट बात है कॉन्ट्रैक्टर को बतानी चाहिए इंजीनियर को, और बताएगा जो आवश्यकता होगी ये सबूत देने के लिए कि हमने काम कंप्लायंस किया है कॉन्ट्रैक्ट के हिसाब से. कॉन्ट्रैक्ट शैल ट्रीट ऑल डॉक्यूमेंट्स फॉर्मिंग कॉन्ट्रैक्ट एज कॉन्फिडेंशियल. Contractor shall treat all documents forming contract as confidential, except to extent necessary to carry out contractor's obligations under contract. Contract shall not permit to be published or disclose any particulars of contract in whatever trade or technical paper or elsewhere without employer's prior consent. Employer and the engineer shall treat all information provided by contractor and marked confidential as confidential. Employer shall not disclose or permit to be disclosed whatever such information to third parties, except as may be necessary when exercising employer's rights under the subclause termination for contractual default. A party's obligation of confidentiality under subclause shall not apply where information was already in that party's possession without an obligation of confidentiality before receipt from other party becomes generally available to public through no breach of these conditions, is lawfully obtained by party from a third party which is not bound by an obligation of confidentiality. Compliance with laws, नियमों के साथ खेल नहीं, आपको नियम तो फॉलो करने हैं. Compliance with laws. Compliance with laws, what we are talking of, is also important here. नियमों का पालन बहुत जरूरी, इस बात को भी समझना होगा. कहने से नहीं, समझने से बात समझ आती है. कहने से कुछ नहीं होता. We have to understand. It's very, very important that we have to understand all this. Oh, I'm sorry. Oh. कानून जहाँ भी होते हैं इम्प्लीमेंटेशन के लिए होते हैं, कहीं पर भी हो चाहे, उसको हम ये नहीं कह सकते कुछ कि क्यों है तो है, क्या करेंगे आप उसमें. कभी कभी हो जाता है, हम नहीं समझते. समझना तो चाहिए. क्या करें, नहीं समझते भाई, क्या करेंगे आप उसमें. कोई बात नहीं है. कभी कभी हो जाता है, हम नहीं समझते, हम क्या करें भाई. नहीं समझ आया हमको, हमारा फॉल्ट तो नहीं है ना उसमें. नहीं आया तो नहीं आया, क्या करे कोई इसमें. नो नहीं, लीव इट. बेकार का टाइम वेस्ट ना करिए. अच्छा उसको बाद में देखेंगे. नो प्रॉब्लम, लीव इट बिहाइंड. आई एम सॉरी, लीव इट behind. I leave this. Continue our work, which is important. Just try to do that one, and it's all that. 1 hour 3 minutes, 13 minutes, and we should do this. Contract and employer shall in performing contract comply with all applicable laws unless otherwise stated in specification. Employer shall have obtained or shall obtain planning, zoning or building permit or similar permissions, licenses and or approvals for permanent works and whatever other permits, all other permits, permissions, licenses and or approvals described in specification as having been or being obtained by employer. Employer shall indemnify and hold contractor harmless against and from consequences of whatever delay or failure to do so, unless failure is caused by contractor's failure to comply with सब पैराग्राफ। सिंपल सा है, जो भी ज़रूरतें हैं आपको प्रोजेक्ट के लिए आगे चलने के लिए कानून के हिसाब से, नियम के हिसाब से, जो भी लाइसेंसेस लेने हैं, परमिट लेने हैं, परमानेंट वर्क्स के लिए वो लेने पड़ेंगे आपको हर हालत में, जो भी नियम उस एरिया का है, उस देश का है, उस सिटी का है। और एम्प्लॉयर आपको सुरक्षित रखेगा, आप एम्प्लॉयर को सुरक्षित रखेंगे, दोनों अपने अपने काम करेंगे। ये नेचुरल होता है, इसमें कोई इतनी बड़ी बात नहीं है। कॉन्ट्रैक्टर shall give all notices, pay all taxes, duties and fees, and obtain all other permits, permissions, licenses, and or approvals as required by laws in relation to execution of works. Contractor shall indemnify and hold employer harmless against and from consequences of whatever failure to do so, unless failure is caused by employer's failure to comply with this clause. Within time stated in specification, contractor shall provide such assistance and all documentation as described in specification or otherwise reasonably required by employer, so as to allow employer to obtain permit, permission, license or approval under subparagraph. Contractors shall comply with all permits, permissions, licenses and or approvals obtained by employer under subparagraph. If having complied with subparagraph above, contractor suffers delay and or incurs cost as a result of employer's delay or failure to obtain permit, permission, license or approval under subparagraph above, contractor shall be entitled, subject to subclause, for payment EOT and or payment of such cost plus profit. If employer incurs additional cost as a result of contractor's failure to comply with subparagraph as above, employer shall be entitled, subject to subclause this, for payment or EOT to payment of these costs by contractor. Now, joint and several liability. Joint and several liability. It's very common clause in contracts and also many other areas. You can say, if contractor is a joint venture, member of joint venture, members of joint venture shall be jointly and severally liable to employer for performance of contractor's obligations under contract. Joint venture leader shall have authority to bind contractor and each member of joint venture JV. Neither members nor, if known, scope and parts of works to be carried out by each member, nor legal status of joint venture shall be altered without prior consent of employer, but such consent shall not relieve altered joint venture from whatever liability under subparagraph above. Limitations of liability. Limitations of liability. Neither party shall be liable to other party for loss of use of any works, loss of profit, loss of contract, or for indirect or consequential loss or damage which may be suffered by either party in connection with contract under other than under. A. Subclause delay damages. B. Subparagraph variation by instruction. C. Payment after termination for employer's convenience. And D. Payment after termination by contractor. E. Intellectual and industrial property rights. F. Indemnities by contractor. G. Indemnities by employer. Total liability of contractor to employer under or in connection with contract. Employer supplied material and employer's equipment, temporary utilities, intellectual and industrial property rights, indemnities by contractor. All these shall not exceed sum stated in contract data, or if a sum is not so stated, accepted contract amount. Subclause shall not limit liability in any case of fraud, gross negligence, deliberate default, or reckless misconduct by defaulting party. Contract termination subject to whatever mandatory requirement under governing law of contract. Termination of contract under whatever subclause of these conditions shall require no action of whatsoever kind by either party. This was about, what we did here. It was about, you can say, employer means owner. Owner of project, though owner is not end user, owner also serves as a like, ultimately employer shall also sell to end users. So for purpose of contract, its employer since is responsible for this project in all respects, and we call it employer. Employer shall give contractor right of access to and possession of all parts of site within time or times stated in contract data. Right and possession may not be exclusive to contractor. If under contract, employer is required to give contractor possession of whatever foundation, structure, plant, or means of access. Employer shall do so in time and manner stated in specification. However, employer may withhold whatever such right or possession until performance security has been received. If no such time is stated in contract data, employer shall give contractor right of access to and possession of those parts of site within such time as may be required to enable contractor to proceed in accordance with program. If there is no program at that time, initial program submitted under subclause, whatever it is. Contractor suffers delay. If contractor suffers delay and or incurs cost as a result of failure by employer to give whatever such right or possession within such time, contractor shall be entitled, subject to subclause, claims for payment and or extension of time and or payment of such cost plus profit. However, if and to extent that employer's failure was caused by any error or delay by contractor, including an error in or delay in submission of and of applicable contractor's documents, contractor shall not be entitled to such EOT and or cost plus profit. Then we can say assistance. Assistance. It's a very important point, though it's contract related but also cooperative as well. It's, it requires cooperation by and between both parties to contract, employer and contractor. If requested by contractor, employer shall promptly provide reasonable assistance to contractors so as to allow contractor to obtain copies of laws of country which are relevant to contract but are not readily available. Permits, permissions, licenses or approvals required by laws copies of laws of contract country which are relevant to contract but are not really available, permits, permission, licenses, approvals required by laws of country, including information required to be submitted by contractor in order to obtain such permits, permission, licenses, approvals which contractor is required to obtain, complies with laws for delivery of goods, including clearances through customs, for export of contractors' equipment when it is removed from site, employers, personnel, and other contractors. It will stretch your body. So I think more than an hour. Yes, it's more than an hour. This is employers, personnel, and other contractors. Employers shall be responsible for ensuring that employers' personnel and employers' other contractors, if it's applicable, on or near site. Now, employer shall be responsible for ensuring that employer's personnel and employer's other contractors on or near site cooperate with contractors' efforts under operation, comply with same obligations which contractor is required to comply with under subparagraph, and safely organization. Cooperate with contractors' efforts under subclause, comply with same obligations which contractors is required to comply with under subparagraph, that is health and safety obligations and protection of environment. Contractor may require employer to remove or cause to be removed whoever person of employer's personal or employer's or other contractors who is found based on reasonable evidence to have engaged in corrupt fraudulence and conspiracy. Contractor may require employer to remove or cause to be removed any person or hmm. employers financial arrangements. पैसा भी चाहिए भाई, कहाँ से आएगा पैसा नहीं तो. That's right. Finance is very important. You cannot do project without finance. Employer's arrangement for financing. Employer's obligations under contract shall be detailed in contract data. It should be detailed. If employer intends to make any material change affecting employer's ability to pay part of contract price remaining to be paid at that time as estimated by engineers. Employers financing employers' obligations under contract shall be detailed in contract data. If employer intends to make material change affecting employer's ability to pay part of contract price remaining to be paid at that time as estimated by engineer to these financial arrangements, or has to do so because of changes in employer's financial situation. Employer shall be immediately given a notice to contractor with details supporting particulars. In contract, if the contractor receives an instruction to execute a variation, if contractor receives an instruction to execute a variation with a price greater than 10% of accepted contract amount or accumulated total of variations exceeds 30% as accepted contract amount, does not receive payment in accordance with subclause, becomes aware of material change in employer's financial arrangements of which contractor has not received a notice under subclause. Contractor may request an employer, and employer shall within 28 days after receiving the request provide reasonable evidence that financial arrangements have been made and are being maintained, which will enable employer to pay. Alright, says contractor may request an employer shall within 28 days after receiving a request provide reasonable evidence that financial arrangements have been made and are being maintained, which shall enable employer to pay part of contract's price remaining to be paid at that time. Cite data and items of reference. It's very important, site data and items of reference, I'm saying. Employer shall have made available to contractor for information before base date all relevant data in employer's possession if employer should have made available to contractor for information before base date all the relevant data in employer's possession on topography of site or on subsurface, hydrological, climatic and then we come to original, employer shall promptly make available to contractor all such data which comes into employer's possession after base date. Original survey control points, lines and labels of reference, or we call them items of reference, in these conditions shall be specified on drawings and or in specification or issued into contractor's allowance. We will move further with little pause here. Employer supplied material and employer's equipment. Employer supplied materials or employer's equipment are listed in specification for information. If employer supplied materials or employer's equipment are listed in specification for contractor's use in execution of works, employer shall make such materials or other equipment available to contractor in accordance with law relating. Mm. Such materials or equipment available to contractor in accordance with details, times, arrangements, rates, and prices stated in specification. Contractor shall be responsible for each item of employer's equipment, whilst either of contractor's personal use is not taken into. Alright, the contractor shall be responsible for each item of employer's equipment while either of these contracts person is operating it, driving it, directing it, ushering it, using it, contract. Engineer. Engineer, very important term, not on contract. Relax for 1 or 2 minutes, better. Engineer. What is engineer? Important point. Employer shall appoint engineer who shall carry out duties assigned to engineer in contract. Engineer shall be vested with all authority necessary to act as engineer under control. This engineer and every and vested interest with all security. Engineer shall be vested with all authority necessary to act as engineer in the control. Engineer as a legal entity, a natural person employed by engineer shall be appointed and authorized to act on behalf of engineer under control, under contract. Engineer is a if a legal entity, natural person appointed to act on behalf of shall be professional engineer having suitable qualifications, experience and competence to act as engineer under contract. Shall be fluent in running language defined in subcontract. Subclause where engineer is a legal entity, engineer shall be given a notice, shall give a notice to parties of a natural person or whatever replacement appointed and authorized to act on behalf. Authority shall not take effect until notice has been received by both parties. Engineer shall similarly give a notice to whatever revocation of such authority. Engineer's duties and authority. It's very important point here. Duties of engineer, authority of engineer. Important point it is. It's very important to understand this clause because here what engineer has to do and that leads to loss of quality or gain of quality. Duties, except as otherwise stated in these conditions, whenever carrying out duties or exercising authority specified in or implied by contract, engineer shall act as a skilled professional and shall be deemed to act for engineer. Engineer shall have no authority to amend contract or accept as industrial price or engineer shall to relieve either party of any duty, obligation or responsibility under or in connection with contract. कुछ नहीं कर सकता इंजीनियर, ज़्यादा कॉन्ट्रैक्ट का सवाल है, उल्टी सीधी रिपोर्ट दे दो, ले दे दो, साइन कर देते हैं और ऐसा नहीं कर। Hmm. Engineering exercise authority attributable attributable to engineer attributed to engineer. Engineering exercise authority attributable to engineer specified necessary to be implied from contract. If engineer is if engineer is required to obtain consent of employer before exercising a specified authority, requirements shall be as they stated in particular conditions. There shall be no requirement in or now there shall be no requirement for engineer to obtain employer's consent prior before engineer exercises authority under agreement or determination. Employer shall not impose such future constraints on engineer's authority. However, whenever engineer exercises a specified authority for which employer consent is required, then for purpose of contract, such consent shall be deemed to have been given. Now, consent report, request, review, test, valuation, or other acts. Uh, Including absence of any such acts by engineer's representative or assistant shall not relieve contractor from any duty, obligation, or responsibilities. Engineer's representative. Engineer's representative. इंजीनियर यार नियुक्त क्या हुआ प्रतिनिधि an engineer's representative and does delegate to that person in accordance with subclause delegation by engineer authority necessary to act on engineer's behalf at site except to replace engineer's representative. Engineer's representative appointed shall comply with subparagraph, that is engineer time that works are being executed, totally absent from equally when say experienced and competent replacement shall be appointed by engineer as a case refuses. Representative temporarily absent from site during execution of works. An equivalently qualified, experienced and competent replacement shall be appointed by engineer and contract shall be given a notice of such replacement. Delegation by engineer. Delegation by engineer. And delegate authority to assistants and may also revoke such assignment or delegation. Duties and assistant. Hmm. Engineer may from time to time assign duties and delegate authority to assistants and may also revoke such assignment or delegation by giving a notice to parties describing assigned duties and delegated the authority of each assistant. Assignment, delegation or revocation shall not take effect until this notice has been received by both parties. However, engineer shall not delegate authority of agreement or determination. Notice to correct. Assistants shall be suitably qualified natural persons. Okay, then can say we may say something about this. Each assistant to whom duties have been assigned or authority has been delegated shall only be authorized to issue instruction to contractor the extent defined by engineer's notice of delegation. Any act by an assistant in accordance with policy stars. shall only be authorized to issue instructions to contractor to extent defined by engineer's notice or delegation, notice of delegation under this subclause. Act by an assistant in accordance with engineer's notice of delegation shall have same effect as though the act had been an act of engineer. However, if in contractor's questions any instruction or notice given by assistant, contractor may be given a notice, you can say instruction lead and struggle with life, lead and struggle. That's what we have to do. Engineer has to lead and struggle everywhere. That's what you are going to do. You shall be deemed to have confirmed, Contractor may be giving a notice. Refer the matter to engineer. Engineer shall be deemed to have confirmed assistant's instruction or notice. If engineer does not give response, then after. Okay. Now think on this. You shall be deemed to have confirmed assistance instructions or notice if engineer does not respond within 7 days after receiving contractor's notice. Reversing or varying assistant's instruction or notice. Engineer's instruction. Engineer may issue to contractor all time instructions which may be necessary for execution of works, all in accordance with contract. Contractor shall only take instructions from engineer or from engineer's representative if engineer is if appointed engineer representative is appointed on assistant to whom appropriate authority is given or to be given has been delegated under subclause delegation by engineer. Engineer's instructions, very important part of contract. Engineer's instruction, a legal document. Engineer's instructions. Engineer may issue to contractor instructions which may be necessary for execution of works. All in variations and contractor shall only take instruction from engineer or from engineer's representative or an assistant to whom a appropriate authority to give instruction has been delegated under delegation by engineer. Subject to following provisions of sub-clause, contractor shall comply with instructions given by engineer or engineer's representative if it is appointed or delegated assistant or any matter related to contract. Even instruction states that it constitutes a variation by instruction shall apply. If not so, altered meaning of instruction any constant. Question is a quote near future. Very serious matter we are taking consideration. Subject to following provisions of subclass contract shall comply with engineer's instructions given by engineer or delegates, detailed and delegate assistance on any matter related to contract. If an instruction states that constitutes variation, it shall apply. If not so, the contract starts considers that instruction constitutes variation or involves work that's already part of an existing variation, doesn't comply with applicable laws, or will reduce safety of works, or is technically impossible. Court shall immediately and before commencing works relate to instruction, give a notice to engineer with reasons if engineer does not respond within 7 days after receiving this notice. By giving a notice confirming reversing or varying institution instructions. Engineer shall be deemed to have revoked instruction. Otherwise, contract shall comply with and and bound by terms of engineer responses. This is then the placement of engineer. Replacement of engineer. If employer intends to replace engineer, employer shall not less than 42 days before intended dates of replacement give notice to contractor of name, address and relevant experience of intended replacement engineer. If contract doesn't respond within 14 days after receiving this notice, by giving a notice stating an objection to such a replacement with reasons, contract shall be deemed to have been accepted replacement. Employer shall not replace engineer with a person, whether a legal entity or a natural person, against whom contractor has raised reasonable objection by a notice under the subclause. Employer shall not replace engineer with a person, whether or natural person against whom contractor has raised reasonable objections by notice. If he is unable to act as a result of death, illness, disability, or resignation, in case of an entity in engineers becomes unable to or unwilling to carry out an office duties other than for a cause attributable to employer, employer shall be entitled to immediately appoint a replacement by giving a notice to contractor with reasons and name, address and relevant experience of replacement. And agreement or determination. Okay, let us see this. Also says employer shall be entitled to immediately appoint a replacement by giving a notice to a contractor with reasons and name, address and relevant experience of replacement. Appointment shall be treated as a temporary appointment until this replacement is accepted by contractor or other replacement is appointed under this clause. Agreement or determination. Agreement or determination. When carrying out duties under subclause, engineer shall act neutrally between parties and shall not be deemed to act for employer. Wherever these conditions provide that engineer shall proceed under subclause to agree or determine matter or claim, following procedure shall apply. Consultation to reach agreement. As agreement or determination is very important part here. When carrying out duties under this subclause, engineer shall act neutrally between parties and shall not be deemed to act for employer. Whenever these conditions provide that engineer shall proceed under a subclause to agree or determine whatever matter or chain or claim, following procedure shall apply. Consultation to each parties. Consultation to each parties. Oh, my stacks, my legs. Sorry, gentlemen, I'm just stretching my legs because my legs are getting stuck. Engineer shall consult with both parties jointly and or separately and shall ensure discussion between parties in an endeavor to reach agreement. Engineer shall commence such consultation promptly to allow adequate time to comply with time limit for agreement under subclause time limits. Unless otherwise proposed by engineer and agreed by both parties, engineer shall provide both parties with a record of consultation. If agreement is achieved within same time limit for agreement under subclause time limits, engineer shall give a notice to both parties of agreement, which agreement shall be signed by both parties. This notice shall state that it is a notice of parties agreement and shall include a copy of agreement. No agreement is achieved within time limit for agreement under subclause time limits. Both parties advise engineer that no agreement can be achieved within this time limits. Whichever is earlier, engineer shall give a notice to parties according and okay, whichever is earlier, just shall give notice to parties accordingly and shall immediately proceed, specified in this clause engineer's determination. The engineer's determination. 2 hours more. Engineer shall make a fair determination of matter or claim in accordance with contract, taking due regard of all relevant circumstances. Within time limit for determination, under subclause time limits, engineer shall give a notice to both parties or his or her determination. Notice shall state its notice of engineer's determination and shall describe determination in details with reasons and detailed supporting particulars. Engineer shall give notice of agreement if agreement is achieved within 42 days or within such other time limit as may be proposed by engineer and agreed by both parties. Time limit for agreement in these conditions after A. In case of a matter be agreed or determined not to claim the date of commencement of time limit for agreement as stated in given subclause of these conditions. In case of claim under subparagraph of subclause claims a date and yes of okay, let me hold on for a few minutes. Meanwhile, relax for 5 minutes, is it now? Better relax for 5 minutes. It's very, boring subject, but very important subject. Boring but important. That's point here. It's it's part of law, but not law as you think. It's not necessary that we need some lawyer to get operation of this, to take it into operation. No, this is not lawyer's document. This is engineer's document. And therefore, engineer has to understand this, not lawyer. This is a document designed by engineers, and therefore it's important. It's, this document is not very easy from, you can say, implementation viewpoint, because it involves work. It's just rights alone or declaration alone. It is related to work, and which is very, very important. And it's very, very important. We have to understand that. You have to understand this point, which is very, very clear. We are engineers. Let us see what to do. let me do something which is also important from some point of view. Let us see how it can be done. Okay, gentlemen, just in 5 minutes. I'll go to terrace and feed for my friends crows or birds. It's also very important part of my sorry, what to do? I'm a cramp person. So I am back here again, and say, in case of a matter we agreed or determined, not a claim, date of commencement of time limit for agreement as stated in applicable subclause of these conditions. In case of claim under subparagraph, claims date, engineer reserves receives a notice under subclause from claiming party. In case of a claim under subparagraph, claims date, the date engineer receives a fully detailed claim under fully detailed claims. In case of claim under subclause, claim of continuing effect, an interim or final fully detailed claim as case may be. Engineer shall give notice of its determination within 42 days or within such other time limit as may be proposed by engineer and agreed by both parties. Time limit for determination in these conditions after date corresponding to its obligation to proceed under last paragraph, consultation to reach agreement. If engineer does not give notice of agreement or determination within relevant time limit, in case of claim, engineer shall be deemed to have given a determination rejecting claim. In case of a matter to be agreed or determined, matter shall be deemed to be a dispute which may be referred to by either party DAB for its decision under obtaining DAB decision without need for notice of dissatisfaction with engineer's determination, and subparagraph of clause reference of dispute to DAB shall not apply. Effect of agreement or determination. Effect of agreement or determination. Each agreement or determination shall be binding on both parties and be complied with by engineer unless and until corrected under this subclause or you can say in case of a determination, it is revised under clause 21, disputes and arbitration. If an agreement or determination is revised under clause 21, disputes and arbitration, if an agreement or determination concerns payment of an amount from one party to other party, contractor shall include such an amount in next statement and engineer shall include such amount in payment certificate that follows that statement. If within 14 days after giving or receiving engineer's notice of agreement or determination, whatever error of typographical or clerical or arithmetical nature is found by engineer, it shall immediately advise parties accordingly. And by party, Party shall give a notice to engineer stating that it is given under clause and clearly identifying error. If engineer does not agree there was an error, it shall immediately advise parties accordingly. Engineer shall within 7 days of finding error or receiving a notice under subparagraph above, as case may be, give a notice to both parties of corrected agreement or determination. Thereafter, corrected agreement or determination shall be treated as agreement or determination for purpose of these conditions. Dissatisfaction with engineer's determination. If either party is dissatisfied with a determination of engineer, dissatisfied party may give a NOD, notice of dissatisfaction, to either party with a copy to engineer. This NOD shall state that it is a notice of dissatisfaction with engineer's determination and set out reasons for dissatisfaction. This notice of dissatisfaction shall be given within 28 days after receiving engineer's notice of determination under subclause engineer's determination, or if applicable, its notice of corrected determination under subclause effect of agreement or determination, or in case of a deemed determination, rejecting claim within 28 days after time limit for determination under subclause time limits has expired. Thereafter, either party may proceed under subclause 21(4) obtaining DAB's decision. If no NOD is given by either party within period of 28 days, stated in subparagraph above, determination of engineer shall be deemed to have been accepted by both parties and final and binding on them. If dissatisfied party is dissatisfied with only parts of engineer's determination, this part shall be clearly identified on notice of determination (NOD). This parts and whatever other parts of determination that are affected by such parts or rely on such parts for completeness shall be deemed to be severable from remainder of determination, and remainder of determination shall become final and binding on both parties as if notice of determination had not been given. In the event that a party fails to comply with the agreement of parties under subclause 3 of final and binding determination of engineer, other party may without prejudice to whatever other rights it may have refer failure itself directly to arbitration under arbitration clause, in which case first and third paragraphs of clause 21(7) failure to comply with DAB decision shall apply to such reference in same manner as these paragraphs apply to final and binding decision of DAB. Meetings. Engineer or contractor's representative. Engineer or contractor's representative may require Other to attend a management meeting to discuss arrangements for future work. And or other matters in connection with execution of works. Engineer or contractors representatives may require other to attend a management meeting to discuss arrangements for future work and or other matters in connection with execution of works. Employers, other contractors, personal or legally constituted public authorities and or private utility companies and or subcontractors may attend whatever such meeting if requested by engineer or contractor's representative. Engineer shall keep a record of each management meeting and supply copies of record to those attending and to employer. At any such meeting and in record responsibilities for whatever actions to be taken shall be in accordance with contract. This is about engineer. Contractor. Now, so far we have covered something that is from employer's end. Employer's end means engineer's end. It means contract end. It means you can say party one end. We are going to deliberate on contractor, that's party 2 on construction contract. An important, very important, you can say, we cannot just deny this fact. Cannot. It should be taken care of, and contractor is a powerful organization on contract because it is contractual party like employer is a contractual party. A party contractor is a second party is a real party because it has to deliver your works physically to employer. It has got a long list of general obligations. Very long list of general obligations depending on what type of contract it is, and construction contract with mega projects you can say. Quantity wise, quality wise, and you can say also quantum of work, cost of work, duration of work are too long, and you can say if it's fast track, it's very important one. You have to understand these points. It is sometimes not easy to understand contracting work. Conception that has been made in mind, generated in mind, doesn't work. Contract should be based on equitable considerations, equity-based contracts. If rights and responsibilities are not clearly defined or well understood, there is no meaning of contract. Contract means a balancing document which neither defeats either party and which can neither helps either party. Contract means both are equal. One party has to do work in exchange of which other party has to make payments. That is what contract is. Because it is construction contract, it involves hundreds of items and we can say thousands of cubic meter of, or you can say thousands of quantities of items of works, human resources, materials, equipments, vendors, all stakeholders, end product, delivery product that is delivered by contractor at end and that has to be used, make it very important that status of contractor is not of an ordinary person, but it's very much professionally organized and responsible, obliged, and liable. We have to take this into our consideration that contractor is a professional organization which have got expertise in its field, not only in its own field, but it is an organization which works on multidisciplinary activities. Maybe employs some subcontractors with that, but even in that case of using services of subcontractors, contractor is an independent organization and responsible one. It owns responsibility of works, permanent works, temporary works, preparatory works, and also materials and all other conditions that work on contract control contractor itself. So if we design a contract, it's our responsibility to give due regards to nature of contract on construction, and contractors should be professionally qualified in each and every respect to fit in with requirements of contractor selecting criteria. You cannot just elect somebody as contractor because it's your friend or it's a relative or it's a known to. Contractor must be qualified and should be fit to job. That is main requirement, is major criteria that all contracts you have. It's responsible work because employer can only finance and take responsibility of construction, but real responsibility goes to contractor, because without support of contractors, mega projects and quantum size projects cannot be delivered. So contractor is a different word here. He is a professional contractor. Actually, I am not talking of just a contractor, but a professional contractor. Contractor shall execute works in accordance with contract. Contract undertakes that execution of works and completed works shall be in accordance with documents forming contract as altered or modified by variations. Contractor shall provide plant and spare parts if required, and contractor's documents specified in contract. And all contractors' personal goods, consumables, and all other things and services, whether of a temporary or permanent nature, required to fulfill contractor's obligations under contract. Contractor shall be responsible for adequacy, stability, and safety of all contractors' operations and activities, of all methods of construction, and of all temporary works, except to extent specified in contract. Contractor shall be responsible for all contractors' documents, temporary works, and such designs of each item of plants and materials as is required for them per item to be in accordance with contract. Shall not otherwise be responsible for design or specification of permanent works. Contractor shall, whenever required by engineer, Submit details of arrangements and methods which contractor proposes to adopt for execution of works. No significant alteration to these arrangements and methods shall be made without this alteration having been submitted to engineer. If contract specifies that contractor shall design any part of permanent works, then unless otherwise stated in particular condition, contractor shall prepare and submit to engineer for review contract documents for this part and whatever other documents necessary to complete and implement design during execution of works and to instruct contractors personnel. These contractors' documents shall be in accordance with specification and drawings and include additional information required by engineer to add to drawings for coordination of each party's designs. If engineer instructs that further contractors' documents are reasonably required to demonstrate that contractor's design complies with contract, contractor shall prepare and submit them promptly to engineer at contractor's cost. Construction of this part shall not commence until the notice of no objection is given or is deemed to have been given by engineer under sub-paragraph preparation and review. For all contractors' documents which are relevant to design and construction of such part shall be in accordance with these contractors' documents. Contractor may modify whatever design or contractor's documents which have previously been submitted for review by giving a notice to engineer with reasons. If contractor has commenced construction of parts of works to which such design or contractor's documents are relevant, works on this part shall be suspended. Provisions of subclause preparation and review shall apply as if engineer had given a notice in respect of contractor's documents under subparagraph of subclause above, and work shall not resume until a notice of no objection is given or is deemed to have been given by engineer or for revised documents. Contractor shall be responsible for this part, and it shall, when works are completed, be fit for such purpose for which part is intended as specified in contract, or where no purposes are so defined and described fit for their ordinary purpose. In addition to contractors undertaking above, contractor undertakes that design and contractor's documents for this part shall comply with technical standards stated in a specification and laws in force when works are taken over under clause employers taking over and in accordance with documents forming contract as altered or modified by variations. If subclause has built records and or subclause operation and maintenance manuals supply, contractor shall submit to engineer contractor's documents for this part in accordance with such subclauses and in sufficient detail for employer to operate, maintain, dismantle, reassemble, adjust and repair this part, and to, if subclause this is training applies, contractor shall carry out training of employer's personnel in operation and maintenance of this part. Then you can say permanent security, performance security. So we can say contractor here, you can say contractor here is required professional who has to carry out job according to demanded requirements included within the specifications, and whatever documents either submitted by engineer and of course proposed by contractor. It can't be, you can say, it can't be considered too easy. It's issue of it's issue of understanding thoroughly what documents say. The contractor you prepare these documents maybe to last 2 days. It doesn't matter 2 days or 3 days as far as documents are concerned. This must be given due weightage. Weightage is a very important part of, you can say, our life. It's not simply this document I'm talking is construction contract. There can be other, that can be EPC turnkey projects in which design is also included. Design means engineering design, procurement and construction. This is called. So this is turnkey project, you may say, in which a contractor has to conduct design, and followed by that it has to start construction projects. Construction, okay, just when it's practical. In EPC, it's not only design that contractor has to do, also contractor has to do all activities that were carried out in past and scoped in contract. In EPC, design responsibility also is shared by contractor, which is very different one. Generally, you cannot say every project EPC is okay. Everything is okay, not everything. We have to see important point here that contractor has to go words by words and drawing by drawing, specify specifications, and speak in that way. Job of contracting company or contractor is very, very difficult in civil engineering construction. Very difficult job. I'm not saying impossible, but difficult job. So it's very important point that we have to concentrate on contracting. Engineering is okay, fine, engineer is good, but contracting is very complicated. It has to satisfy everyone, including his own self. It's also true. Yes, we have to consider all these points. Contracting is not that small business. It's very expensive business, and it's cost business. It's time business. We have to save costs. We have to save time. We have to get quality more and more and added value, and we have to think of every point and engineer and contractor think together. Question is quality and speed of quantity both should be in same page on same page, and that's where we are effective with this. So what I actually say in this regard, कॉन्ट्रैक्टिंग ठेकेदारी कहने को तो हम गलत वे में कहते हैं, लेकिन जहाँ बात जिम्मेदारी की है, अच्छा स्ट्रक्चर बनाने की है, जहाँ बात आपका पैसा आपको वापस मिले वो है, सरकार का पैसा है या जो भी प्रोजेक्ट का पैसा है, वहाँ एक जिम्मेदारी होती है कॉन्ट्रैक्टर की कि वो सही तरह से बना के दे, बहुत आवश्यक है। स्पेसिफिकेशन को फॉलो करे, ड्राइंग को फॉलो करे, जो भी रूल्स एंड रेगुलेशंस उनको फॉलो करे, और कोई इधर उधर ना करे। जो उसमें कहा गया है डिज़ाइन में, जो कहा गया स्पेसिफिकेशन में, वैसा ही बना के दे। वो बनाता है, अगर आप उसको सही तरह से रेट्स देंगे तो प्रोफेशनल है तो काम करेगा, और काम अच्छा होता है, मशीन ज़्यादा होती हैं और एक्सपर्ट्स ज़्यादा होते हैं तो अच्छा काम होता है। और ये नहीं कि ये यहाँ नहीं हो सकता है, यहाँ वहाँ नहीं हो सकता है, सब जगह हो सकता है। ये आपके सोच के ऊपर है, वर्क कल्चर के ऊपर है कि आप किस तरह से प्रोजेक्ट देना चाहते हैं। मतलब क्या कहूँ इस बारे में, बहुत इम्पोर्टेंट बात होती है। कॉन्ट्रैक्टिंग आसान नहीं होती है, क्योंकि मैं भी झुलसा हूँ कॉन्ट्रैक्टिंग में। बात पैसा कमाने की या ना कमाने की नहीं है, पैसा तो सभी कमाते हैं जब काम करते हैं। इंजीनियर भी तो फीस लेता है, एम्प्लॉयर भी सोच रहा है मैं इससे बहुत कमाऊंगा, तो अगर थोड़ा कॉन्ट्रैक्टर भी कमाएगा तो उसमें कोई ऐसी गलत सोच नहीं है। हाँ, वो हेरा फेरी ना करे, झूठ का काम ना कराए तो ठीक है, हम मानते हैं भाई वो भी एक हिस्सा है समाज का, और क्वालिफाइड एक्सपीरियंस है, वहाँ ऐसा नहीं होना चाहिए, लेकिन ऐसा होता है। और ये बातें, इफ़ यू अंडरस्टैंड ऑल दिस, यू कैन से ओके फाइन, यू हैव गॉन थ्रू basic requirement of contracting, and that is thought, good thought. If you don't have good thought, you cannot do anything. If you think of criminality in mind, you cannot move further. It's question that where do we stand, how do we move, that's more important. Material we are going to produce or use means it be qualifying material. It's not simple material, even steel steel hinges or plastic hinges or all these materials which we go through, we understand well, it's fine. It's very, very fine. I can say we have to consider very seriously issue of contracting. It's very serious issue in fact because it it delivers something permanent. It delivers something permanent for permanent use, and it deals with multi resources same time. It deals with money, it deals with materials, it deals with machines. कॉन्ट्रैक्टर को मैं इसलिए जोर दे रहा हूँ कि कॉन्ट्रैक्टर के बिना काम नहीं चलता है। अगर आप खुद करा सकते हैं तो कराइए, कोई रोकेगा नहीं आपको, लेकिन मैं ये भी जानता हूँ आप नहीं करा पाएंगे। आप वर्कर्स भी नहीं ढूंढ के ला सकते, बाकी तो छोड़िए। इसलिए मैं अच्छी तरह जानता हूँ कि कंपनीज काम नहीं करा सकती, वो इंजीनियर्स के भरोसे रहती हैं। जब हड़ताल हो रही होगी तो इंजीनियर्स कहाँ होंगे? वो उनकी राय में तो शामिल नहीं होंगे। इसलिए हमको ये बात को अच्छी तरह से समझना चाहिए, कैसे आगे चलना है। से बात बन जाएगी और हम आगे चलते जाएंगे। ये बहुत ज़रूरी है समझना इस बात को, और अगर हम समझते हैं तो ठीक है, अच्छी बात है। नहीं समझते तो नुकसान तो हमारा ही है, किसी और का तो है नहीं। और वो नुकसान है। वर्क और विश्वास बड़ी चीज़ें हैं। कॉन्ट्रैक्टर को हमेशा गलत कहना भी हमारा दिमाग की कमी है। काम भी वही करता है। इंजीनियर का काम है देखना कि वो सही काम करता है कि नहीं करता है, सिंपल सी बात है। तो दोष हम कॉन्ट्रैक्टर को दें कि इंजीनियर को दें, ये फैसला आप कीजिए। क्योंकि अगर इंजीनियर भी अपना काम नहीं करता है, ठेकेदार के साथ मिल जाता है, माना ठेकेदार गलत है तो इंजीनियर भी तो गलत है, ये बात भी समझ लीजिए। इसलिए दिमाग से एक जो माइंड सेट हो जाता है कई बार कि ये सब चोर होते हैं। हम लोग तो सोच लेते हैं ऐसा ठेकेदार चोर है। मैं उन बड़े ठेकेदारों की बात कर रहा हूँ जो प्रोफेशनल कॉन्ट्रैक्टर्स हैं, उनके बारे में ऐसा नहीं कह सकते। हमारे देश की बातें छोड़ी, हम बात वर्ल्ड की कर रहे हैं। ये कहना कि सब चोर हैं, सब ऐसे हैं, सब वैसे हैं, ये सब काल्पनिक दुनिया है सोचने वाली। सच्चाई में तो ऐसा नहीं है। और वो चोर हैं या नहीं हैं, उन बातों को छोड़ो। उनकी जिम्मेदारी, उनका उत्तरदायित्व, उनकी रिस्पॉन्सिबिलिटी को देखो कि वो क्या करते हैं। सामान खरीदना, वर्कर्स को अरेंज करना, जिम्मेदारी लेना, बनवाना। अगर आप सोचिए, अगर आप आज नहीं है आपकी ठेकेदारी करें, अगर ऐसे होते, ऐसे तो बहुत आए थे, बहुत लोग ऐसे थे। We have to understand all this point that responsibility of construction goes to contractor, and contractor has to deliver all this. If contract is not respected, means that way to that level, you can't expect to get delivery of that one. That point's really very, very becoming. We have to, we cannot say we have to understand that point. Without contractor, if you can do job very fine, do it. Nobody is stopping you. But if you don't have capacity to do that, because it is arrangement of every material that you have to do, and you are not capable, you're not happy to contribute to project that hard work, and that's the only reason you try to get contractor into play. And when the contract comes into play, contract doesn't come here just to serve you free. Contract charges for that. The charges accommodation. And during the charge you came to know that your engineers protected in ditches or acid. This point I would like to say, I'd like to clarify this again and again. Don't underestimate others. Underestimation has no value. Requirement is value. Without requirement, you cannot do anything. And contracting is a requirement. Requirement because without contracting, project cannot come up. Controls are required. Supervision and surveillance are required. And we can do that very well if we do. And if you don't want to do, you can blame others. It's very common. We can blame others, and then we can say fine. We blame others, and that's it. We can say nothing else. We may say that, but it's not true always. We have to be very specific in this regard. We have to be more conducive in this regard. We have to face situation according to requirement, according to project. And with this, I like to close this. I will close this talk today. Thank you very much. We'll see again.